Does anybody know?
I can.
Your Honor, Stephanie.
Let me hear from one at a time. Excuse me. Let me do this one at a time. Oh, thank you very much. Let me ask Ms. Cummings, because she may know, and then of course I'll get your position as well, Ms. Peoples. Ms. Cummings, do you know whether the Miami-Dade School Board people walked away with sufficient information to put together an IEP?
No, Judge. The short answer is no. It is my understanding, according to Ms. Langer, that the materials have been sent, but the officials that were there indicated that they have not received anything.
Okay, so what's the next step?
The next steps were for Mr. Rosa to complete some documentation and send that back to Dade County Public Schools. In addition to receiving all of his records for their review. Then it's going to take about 60 days in order for them to do the evaluation, review the document, do the evaluation, and then to set another meeting with the family to discuss whether he's eligible or not.
That timetable doesn't sound very good. Is there any reason why they can't do it more quickly?
Your Honor, may I?
I don't have an answer to that.
All right. Now, Ms. Peoples, you wanted to weigh in on this. Let me hear from you.
Your Honor, it was just a clarification that the defense had requested the IEP, not the Department of Corrections.
Oh, good.
In the request for the IEP, the initial meeting, the one that we're discussing now, it wasn't to actually, the school board has a certain function and order for procession. So that first meeting was to set things up towards the IEP, to get the family, to get the records. The school board has to do their own independent testing and analysis. So that was just that first meeting for the school board, so to speak, to get the parties together and move forward with it. Since then, we have sent records over to the school board that they didn't have at that specific meeting, but it wasn't a 504 nor an IEP at that very first meeting. Because it takes time to organize and pull in all the parties necessary, which is part of the reason for the request for clarification, because these are statutory outlined as to who's to participate, such that even the school board attorney can't participate in these meetings. So that's why we're objecting to Petitioner Jones Cummings' participation in the meeting. And that's kind of what we were trying to get clarification on today.
Well, you raised the concerns not only of education, but also of the amount of time that the young man is in his cell, notwithstanding a visual check by a supervisor every 10 minutes. And from the information we gathered in December, they seem to pay very, very, very close attention to Derek. But my concern about your records were you raised these issues. And just like when you have asked for a competency determination, or you raise insanity or any other psychological issue, you've raised it. And now it's open. And since you believe it's a part of the reason why you believe that Miami-Dade Corrections is not the appropriate place, they're responsible for his conditions. Why would they not be entitled to? Ma'am, I am actually legally permitted to interrupt you, but and I'll try not to unless it's really for order. But I'm going to ask you not to interrupt me. That's just not the way it works. That's quite all right. I sorry to have to say it, but it is. So if your allegations are because of his ADHD and autism, the jail is not sufficient. This jail is not sufficient. Why would the jail not be entitled to be able to look at his records to determine if, in fact, it's as severe as you want some people to believe? And second, are there accommodations they could make? So it would seem that by raising the issue, you've opened the door to this. I'm going to suggest this. And tell me if it works for you. Because the jail needs to be aware, they provide the doctors. They have a contract with JMH to provide the medical facility, the doctors that look at him physically, the psychologists that look at him mentally. And as I understand it, correct me if I'm wrong, Ms. Jones-Cummings, but my understanding is that there's at least a weekly medical and psychological check going on with this young man. I've seen these records before. They do a daily psychological check. So they are not held, however, by Miami-Dade Corrections and Rehabilitation. They're held by JMH. So when I hire a doctor to do a psychological evaluation, I enter an order authorizing them to review the JMH records. Why would it not be appropriate here for me to enter an order that Miami-Dade Corrections and Rehabilitation, to the extent they need it, have access to the JMH records with a very strict confidentiality provision that they may not disseminate it to anyone else except those who are essential within their legal team and to do the analysis? Why would that not be the appropriate thing to do?
May I?
Yes, ma'am.
So thank you, Your Honor, for the request, for your clear outline of the court's position. In similar,
No, ma'am, it's not I don't take a position, ma'am. I review the law, I review the evidence, and I rule. It's not a position. What I do is enter orders, okay? So what I've done is, it's not a position. If the facts and the legal analysis that I've just explained to you are incorrect, then you need to tell me that and provide for me law and or evidence which indicates otherwise. I don't take positions, ma'am. I issue orders. Go ahead.
So in a similar vein with as the court raised the competency example, these are records that the hospital, because the hospital is bound by HIPAA, would not release just freely. So Patricia Jones in the court, when the defense had raised this issue of autism, ADHD, provided an order and put in quotations